Tonight, we're going to talk about the power of words. Of course, they're used to create beautiful poems, convey a wide range of emotion, maybe explain a complex set of instructions. And of course, there's much more. Because in some cases, especially when it comes to legal battles, once the words are written down, then the fight begins over what those words mean. And that is our big story tonight. The power of words will come into sharp focus in the next few months as Oregon's highest court is asked to sort out the meaning of Initiative 113. That's the constitutional amendment that tried to stop the walkouts in Oregon's legislature that halt the state's business. Republicans have done it several times recently, but the Democrats did it before that. The Secretary of State recently ruled that 10 Republicans cannot run for re-election because they boycotted part of the last legislative session. And now there's a court case brewing over that decision and over the meaning of the words which give Measure 113 its power. Both the lawyer representing Republicans and the Attorney General's office now have asked the state Supreme Court to take a look at this and give them an answer soon. Measure 113 passed by a landslide. It's in Article 4, Section 15 of the Oregon Constitution. Not a whole bunch of words there, but enough. Let's take a look at the words. Failure to attend without permission or excuse 10 or more legislative floor sessions called to transact business during a regular or special legislative session shall be deemed disorderly behavior and shall disqualify the member from holding office as a senator or representative for the term following the election after the member's current term is completed. Okay, so those are the exact words in the Oregon Constitution that this whole fight's brewing over. Those are the words that people put in the Constitution when they voted yes by a landslide on this thing. But now there's a prominent Portland lawyer, John DiLorenzo, who's working for the Republicans to get them out of what seemed to me like a pretty open and shut case. Cause and effect. Skip 10 or more days of the session, you don't get to run for re-election next time. Now, I got to tell you, I have a lot of respect for DiLorenzo, and when he's involved, his side always has a shot at winning. I talked with him earlier today.
What was portrayed in the voters' pamphlet and reported by the press does not equate to the actual language that was used in the constitutional amendment.
Oh boy, so the power of words again. DiLorenzo has latched onto those words, election after the member's current term is completed. And that's trickier than it sounds because the election for the next term, well, that happens before the current term is over. Specifically, when it comes to Senators Knopp, Finley, and Linthicum, their term is not completed until January 14th of 2025. The election to see who serves that next term, well, that happens earlier in November 5th of 2024. And that's the one the Secretary of State has said they cannot run in. But DiLorenzo argues that's just wrong, that the wording of Measure 113 impacts the first election after the member's current term is completed. And since their current term ends in January of 2025, the next election for that seat is not until November of 2028. And the same thing happens for Senators Weber and Bonham, but 2 years later. So those are the 5 GOP senators named in the court action: Knopp, Finley, Linthicum, Weber, and Bonham. An interesting argument on the technical wording, and DiLorenzo says this is just the first step, by the way, to getting Measure 113 overturned.
Now, the reason this is important is because we are also planning to challenge whether or not Measure 113 violates their rights to free speech, association, and due process. But before we do that, we have to figure out what it means.
All right, but what about, the Secretary of State saying, listen, what the voters mean was if you stage a boycott, you can't run for election next time?
Well, the Secretary of State is saying, well, it obviously means what we think the voters intended. And what we think the voters intended is based on what they read in the newspapers and what was in the voters' pamphlet. And my rejoinder to that is, if the court is faced with a choice, implement what the measure clearly and unambiguously says versus what somebody thinks the voters intended, you stick with the unambiguous language of the constitutional amendment.
right. But do you think that the voters really would have approved a measure that says you can actually run for, it has the effect of saying, well, all right, you can run for the next term, but the term after that, by golly, you cannot come back?
Well, I don't know whether the voters would have intended that or not. The point is, who is anyone to say what the voters intended without polling the voters? And the best poll is an election.
Which does bring up another point here. Even if Republicans do win this court battle, they may still lose the bigger war. I guess we'll know the will of the voters if those GOP senators are allowed to run for re-election in November of 2024 and then end up getting tossed out on their ear by the folks in their district. DiLorenzo, by the way, thinks it may be 6 months before we get a final answer on this question. We'll keep an eye on it for you. In the meantime, what do you think about this? Does the lawyer for the Republicans have a point there? Did you vote for Measure 113? What was the message you wanted to send? Let us know, will you? Our email is thestory@kgw.com. The voicemail is 503-226-5090. I look forward to hearing from you.